The, the man, X was driving his car. While X was driving his car, it's about 10 o'clock in the evening. He saw a man on the street. The man was lying. The man was full of blood. He stopped. He looked at the man. The man, bathed in his own blood, saw X and asked help from X. But X, instead of alighting from his car, became afraid. People might thought he's the one who hit the man. And so, instead of helping the man, X left the said man and even increased speed and left the place. Meanwhile, the man was seen by the people in the neighborhood and the said man was brought to the hospital. The man survived. The man was so mad at X, and so he filed a case at X. He was so mad at X because he asked help, assistance from X, the first person who saw him, but X failed to give or render any assistance. And so he filed a case of violation of Article 275, abandonment of persons in danger against X. Is X liable as charged? X is not liable as charged. Under Article 275, the following persons are said to be criminally, the following acts are said to be punished for abandonment of persons in danger or abandonment of one's own victim. First, by failing to render assistance to any person whom the offender has found in an uninhabited place, wounded, and in danger of dying, when he can render such assistance without detriment to himself. Or, by failing to render help or assistance to any person whom he has accidentally wounded or injured. And lastly, by failing to bring a child under 7 years of age whom he has found abandoned to the parents, to the authorities, or failing to bring him to a safe place. These are the acts punished under Article 275. The problem falls on the first act. There was this person wounded, in danger of dying, lying on the street. X was the first one to see him. This person asked help from X, but X failed to give help. Yet, X is not liable. X is not liable because although this person is wounded and in danger of dying, the street is not an uninhabited place. Any person could render assistance with. In fact, the people in the neighborhood saw him and brought him to the hospital. Therefore, in the said place, there is great possibility of receiving help. It is not an uninhabited place. Hence, X cannot be held criminally liable. Under Article 276, the law punishes abandoning a minor. Abandoning a minor is committed by any person who, having custody of the said minor under 7 years of age, should abandon the said minor permanently, consciously, and deliberately absent intent to kill. So here, the offender has no intention to kill the said minor, which is within his custody when he abandoned the said minor. If, however, the minor died, or if the life of the minor was placed in danger, the penalty will be qualified. The husband and the wife got separated. It was a separation in bed, not a legal separation. Since their separation, the husband no longer goes home. It was the wife who was all providing for their only child, a girl who is 10 years old. She was giving the child basic necessities, schooling the child in a private good school. But this mother became very ill, and so she has to resign from work. And because of that, she lost her means to provide for the basic needs of her daughter and to bring the girl continuously to a good school. And so what the mother did, the mother demanded help as support from the husband. The husband happens to come from a very wealthy family. But instead of giving support, the husband did not give anything for the basic needs for the education of the said young girl. What former crimes should be filed against the said father? First, the father should be charged under Articles 277, second paragraph, indifference of parents. Second, the father should be charged for violation of RA 9262 for his unjustified failure to give support. These two cases can proceed independently of each other. One is a violation of the RPC, one is a violation of the special penal law. Under Article 277, there is indifference of parents when a parent failed to give his child the education that his financial capacity or station in life can provide. The father is rich, yet he refused to provide for the good schooling of the girl, therefore he is liable for indifference of parents. And his unjustified failure to give support to the minor daughter would also amount to a violation of RA 9262. Under Article 280, we have trespass to dwelling. Under Article 281, we have trespass to property. Trespass to dwelling is committed when the offender is a private individual and he enters the dwelling of another and the said entry is against the will of the latter. In case of trespass to dwelling, the offender is a private individual or a public officer acting in his private capacity. Reason is, if the offender is a public officer, the crime committed is violation of domicile under Article 128. In case of trespass to dwelling, if the act of entry is done by means of violence, by means of intimidation, the penalty is qualified, so the crime committed is qualified trespass to dwelling. In case of trespass to property, the offender entered the closed premises or fenced estate of another, which at the time of the entry is uninhabited. Prohibition to enter is made manifest, yet the offender entered without seeking permission or consent from the owner or the caretaker. In case of trespass dwelling, the place entered into being a dwelling is inhabited, whereas in case of trespass to property, the place entered into is uninhabited. In case of trespass to dwelling, prohibition to enter can either be expressed or implied, whereas in case of trespass to property, prohibition to enter is made manifest. In case of trespass to dwelling, the offender entered the dwelling of another against the will of the owner. In case of trespass to property, the offender entered the property of another without securing consent, permission from the owner or the caretaker thereof. In case of trespass to dwelling, it can be committed only by a private individual or a public officer acting in his private capacity, whereas in case of trespass to property, it can be committed by any person, private individual, or public officer or employee. The couple went on a vacation for Hong Kong for 2 weeks. They left the place. No one is inside their house. They left early morning. In the afternoon of that day, neighbors saw waters on the street very near the house of this couple who went on vacation. The portion of their street were already flooded. They did not mind it at first, but the following morning, when the neighborhood woke up, they saw great portion of the street was already filled with water. And one of the neighbors, W, realized the water was coming from the house of this couple. And so in order to see what was that water, W forcibly opened the lock of the door, entered inside, and there he saw there was a faucet left open in full. So water, huge amount of water were coming out, getting out of the house, flooding the street. And so what W did, he turned off the faucet. And then thereafter, he brought a new lock and locked the house. 2 weeks thereafter, the couple arrived. They learned what W did. They were so mad. He has no business to enter their house. And so they filed against W qualified trespass to dwelling, violence was employed in breaking the law. Is W liable as charged? W is not liable of qualified trespass to dwelling. Under Article 280, there are certain instances wherein even if a person entered the dwelling of another, he cannot be held liable for trespass to dwelling. That is, when the entry to another person's house is for the purpose of preventing serious harm to himself, to the occupant of the dwelling, or to a third person. Or, when the entry to another person's house is done to render some service to humanity or justice. Or when the place entered into is a cafe, tavern, inn, or any other similar public establishments, and at the time it is open. The problem falls on the second act. W entered the place to render service to humanity and to justice. If he would not turn off the faucet for 2 weeks, the streets would be flooded, and huge amount of water would be wasted. Hence, it is an act for justice, for humanity. He cannot be liable for violation of Article 280. There are 3 kinds of threats. We have grave threats, we have light threats, and we have other light threats. The following acts are punished as grave threats. By threatening another with the infliction upon his person, honor, or property, or that of his family of any wrong amounting to a crime, coupled with the demand of money or the imposition of any other condition, even though not unlawful, the offender attaining his purpose. Second, by threatening another with the infliction upon his person, honor, or property, or that of his family of any wrong amounting to a crime, coupled with a demand of money or the imposition of any other condition, even though not unlawful, the offender not attaining his purpose. And lastly, by threatening another with the infliction upon his person, honor, property, or that of his family of any wrong amounting to a crime, the threat not being subject to any condition. These are the acts punished as grave threats. Light threats, on the other hand, is committed when a person threatens another to commit a wrong which does not amount to a crime, but is always coupled with a demand of money or the imposition of any other condition, even though not unlawful, regardless of whether the offender was able to attain or not attain his purpose. So, how is grave threats different from light threats? In grave threats, the wrong threatened to be committed would always and always amount to a crime. Whereas in case of light threats, the wrong threatened to be committed would not amount to a crime. In case of grave threats, the giving of threat may or may not be subject to a demand of money or any other condition. But in case of light threats, the wrong threatened to be committed is always and always subject to a demand of money or the imposition of any other condition. The essence of both grave threats and light threats is the promise of a future harm or wrong. Its essence is intimidation. The wrong the accused threatened to commit is not now, not imminent. It is in the future. Hence, grave threats and light threats can be committed not only personally, but also in writing or through a middleman or third person. And if the said grave threats or light threats is committed in writing or through a middleman, the penalty is qualified. The other kind of threat is the so-called other light threats under Article 285. There are 3 acts punished as other light threats. First, by threatening another with a weapon, or by drawing such weapon in the course of a quarrel unless it be in lawful self-defense. Or, by orally threatening another in the heat of anger with some wrong amounting to a crime, without the offender persisting with the idea involved in the threat. And lastly, by orally threatening another in the heat of anger with some wrong not amounting to a crime. Other light threats is only a light felony. The penalty is only arrest to menor. If the offender threatens another with a weapon, it is only other light threats. If the offender threatens threatens to commit a wrong that amounts to a crime, but it was done orally. In the heat of anger, the accused was very angry, very mad, and he was threatening the victim. But there is no showing that he persisted with the idea involved in the threat. It is only other life threats. And if in the heat of anger, he threatens to commit a wrong which does not amount to a crime, it is only other life threats. The accused, or X, poked a gun at Y, staring at Y for a few seconds while poking the gun. Thereafter, he left. Is X liable of any crime? X is liable of other life threats. But what if in the same problem, when X poked the gun at the head of Y, while staring at Y for a few seconds before he left, he said this word, "I will kill you the next time I see you." This time from other life threats, it is now grave threats. Because the wrong now threatened to be committed would amount to a crime, killing, therefore homicide. If the wrong threatened to be committed would not amount to a crime, it is only life threats, provided it is subject to condition or demand of money. X talked to Y, his office mate, and told Y, "I discovered you are not paying the correct taxes. I will inform the BIR that you are not paying the correct taxes if you will not give me 100,000 pesos. Y did not give any amount. Is X liable of any crime? X is liable of life threats. Telling the BIR that the taxes paid by Y is not a crime. It would not amount to a crime. But it becomes a wrongful act because it was subject to a demand of money. It is akin to blackmailing. Hence, X would be liable for life threats under Article 280. X told Y, "You pay me your debt now. Based on our agreement, your debt will be paid within a month." A month had lapsed. In fact, it is now on the second month. You have not been paying. You pay me right now. However, Y said he has no money. And so X gave the warning. "I will come back tomorrow morning, same time. You better produce the money. If you will not produce the money, something bad will happen to you and to your family. You will no longer see the next light of day." And so, he left. Is X liable of any crime? X liable of grave threats. He threatened to commit a wrong that amounts to a crime. It is not now, it is not impending to happen. It is in the future, the following day. Therefore, it is grave threats. But what if in the same problem, X told Y, "Pay me your debt now. You better pay me now." Y said he has no money. And then thereafter, X told Y, "If you are not going to pay me now, I have here my friends, and my friends will mow you. My friends will box you, will injure you. So you better pay me right now." However, Y didn't pay. What crime, if any, has been committed by X? X is liable for grave coercion, in particular, compulsive coercion. What if in the same problem? Since what? So X told Y, "You pay me right now. Otherwise, my friends will attack you, hit you, stab you." But Y said he has no money. And so indeed, the friends came and the friends attacked Y. They repeatedly boxed him and injured him. He was brought to the hospital. The doctor said he would be incapacitated from labor for a period of 35 days. What crime should be filed against X and company? Is it still grave coercion? No more. It is already serious physical injuries the grave coercion is now absorbed by the said serious physical injuries because they actually inflicted physical injuries on the said victim. There are two kinds. There are two kinds of grave coercion under Article 286. We have the so-called compulsive coercion, and the other one is preventive coercion. Preventive coercion is committed when a person prevents another from doing an act which is not prohibited by law, by means of violence, threats, or intimidation. So the moment the offender prevents another from doing an act that prohibited by law, therefore a lawful act by means of violence, threats, or intimidation, is liable for compulsive coercion, in particular preventive coercion. The other is liable, for grave coercion, in particular preventive coercion. The other one is known as compulsive coercion. There is compulsive coercion when the offender compels another to do an act against his will, whether it be right or wrong, by means of violence, threats, or intimidation. Regardless of whether the act one person is compelling someone to do is right or wrong, that is immaterial. If he is doing it by means of violence, threats, or intimidation, he becomes liable for compulsive coercion because no person can place the law on his hands. Under Article 287, there is light coercion. Insofar as light coercion is concerned, there is this third kind of light coercion, which is known as unjust vexation. Light coercion is more of a creditor-debtor relationship. The creditor seizes anything pertaining to the debtor by use of force, by use of violence, and he applies it in taken to the said indebtedness. But the third kind of light coercion is the so-called unjust vexation. Unjust vexation refers to any human conduct which, although not producing any injury, unjustifiably vexes, irritates an innocent person. So it is an act that irritates, vexes, annoys an innocent person. It is unjust vexation, a form of light coercion under Article 287. Other similar coercion is more of employer-employee relationship. We go to discovering of secrets. In case of discovering of secrets, we have discovering secrets through seizure of correspondence. We have also revealing secrets with abuse of office. And then we have also revelation of industrial secrets. Discovering secrets through seizure of correspondence is committed by any person who shall seize the correspondence of another with the intent of discovering the secrets of the said person. The mere act of seizure in order to discover the secrets of another will already give rise to the crime. Note that revelation is not an element. Likewise, there is no need to prove damage on the part of the offended party. In case of revealing secrets with abuse of office, however, the mere act of discovering secrets will not suffice. There must be revelation. This is committed by any employer, servant, who, after learning the secrets of his principal or master, shall reveal the same. It is the act of revelation that will give rise to the crime, but again, there is no need of proof of damage on the part of the said master or principal. In case of revelation of industrial secrets, here, it is committed by any person working in a manufacturing or industrial establishment, and as a worker, he learns the secrets of the industry, of the establishment. He reveals the same to the prejudice of the owner thereof. So this time, the law requires there must be proof of damage on the part of the establishment, proof of damage on the part of the industry. It is necessary that upon revealing the secrets of the industry has been damaged. Absent damage, there is no revelation of industrial secrets as a crime. I'll go back to coercion. I forgot something in coercion. Coercion is different from threats in the sense that insofar as coercion is concerned, it is to be done now, personally, and directly. Therefore, Coercion cannot be committed in writing or through a middleman because it is always personal, direct. It is at the point of happening, impending to happen. It is not in the future. We go to Title 10, Crimes Against Property. You have your lunch break. By the look in your eyes, I know you're saying, can we have our lunch? So you have your lunch break. So we come back on